All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. We are here this morning to hear argument in Sulphur Springs Valley Electric Cooperative versus the Arizona Department of Revenue. Our cause number is CR2 Each side will have 20 minutes. We'd ask you to identify yourself and your client when you begin, and the appellant will have to reserve whatever time that you'd like. If you pay attention to the time, and you can try to reserve some if you'd like. We have conferenced this case this morning. We've read the briefs, and I think we're familiar with the arguments. And with that, you may begin.
Thank you. Good morning. My name is Douglas John. I'm with the law firm of Fraser, Ryan, Goldberg, and Arnold, and I'm here on behalf of Sulphur Springs Valley Electric Cooperative. I'd like to reserve 5 minutes, if I can, for rebuttal. At issue in this case is whether Sulphur Springs has rebutted the statutory presumption that the department's valuation of its property is correct and lawful. We believe that the record and the briefing in this case demonstrates that Sulphur Springs has rebutted the presumption of correctness. In addition, Sulphur Springs has rebutted the presumption of lawfulness or validity in this case by demonstrating the department's valuation stems from an invalid rule and it's not based on standard appraisal methods and techniques. A valuation determined without the benefit of rule, regulation, or statutory authority cannot and should not benefit from the presumption of validity.
Well, there's one rule, isn't there, from Graham County?
One rule in what respect?
The Graham County case constraining the methodologies that are appropriate for use in this context?
The rule in Graham County had to do with whether or not the valuation method, in that case a direct income capitalization method, was a standard appraisal method or technique, and they ruled no, it was not.
Right.
Right.
And so to the extent that income calculations are out under Graham County, isn't that a rule, a guideline that should guide our consideration?
I think it's one. I think yes, it is. I think that's what we're mentioning as well, is the validity of it as well. Mm-hmm. We're not hanging our hat just on the validity of it, but in this case we believe that the department's valuation, because it was a product of an invalid rule and did not rely on standard appraisal methods and techniques, should not be given the presumption of validity in this case. But,
well, Counsel,
sorry.
Didn't you concede below that the department had in fact used a type of a standard appraisal method and technique? I'm looking actually at the response to the department's cross motion for summary judgment. Sulphur Springs states there is no dispute in this case the department is using some type of SAMT, or standard appraisal method and technique.
You're correct. I believe those statements were made in oral argument, but I believe they're wrong. If you look for, I believe they're wrong. Through further briefing, if you look at both the Heaton report, which is discussed extensively in the case, I think it's clear that the methodology that the department has been using all these years is not tied to any standard appraisal method and technique. So you're correct. That statement was made, but I believe that statement was made in error.
And was that the methodology that was used here, was that in fact a product of some negotiation between the taxpayers, industry, and the department up to a point, and then it broke down?
That is correct as well, but there was never any formal, it never went through the APA rulemaking process to be
Really,
formal.
I'm sorry, does it really have to be a rule? I mean, as long as the department is using a standard appraisal method, who says there has to be a rule?
Well, again, we don't believe it is a standard appraisal method. And I think the Heaton report, again, points that out quite clearly. If you look at the response, the department absolutely had no response to our critique about the Heaton report in any of their responses at all. They couldn't offer one because there really isn't one. The Heaton report makes clear that both their cost approach and their market approach are not standard appraisal methods. It's not found in any appraisal text that is known at all.
So your argument really isn't, well, they're using a rule. It doesn't matter whether there's a rule or not a rule. Your argument is the department is not using a standard appraisal method, and therefore their valuation, we've rebutted their valuation.
I think in part, but I do think that they are using the methodology they're using. First of all, it's not a standard appraisal method and technique. So secondly, it would have to be promulgated as a rule, and it was never promulgated or adopted through the APA
Why
rulemaking
does
process.
it have to be promulgated as a rule? If it's consistent with what the Supreme Court said in Graham County, does it have
But
the
the
effect of
methodol-
being a rule?
The methodology that the department is using is not consistent with that. It's a rule that was made up long after Graham County was heard. Graham County was heard in 1973. This, I
Agree
believe,
it's
is
consistent with Graham County?
the department's methodology? No.
Why? Does it use income?
No, it uses a cost approach, which, again,
Graham County did not disallow, right?
correct. That is correct.
So why is it inconsistent with Graham County?
Because the methodologies within their cost approach and their market approach are not standard appraisal method techniques. The criteria used within that approach does not stand the scrutiny of being a standard. They can label it a cost approach, but it's not, in fact, a valid cost
But
approach.
wasn't the cost approach actually approved by the Supreme Court in the TRICO, one of the TRICO cases?
Correct, yes.
So what am I missing here? If the department is using a valuation method that is based on a cost approach and is not based upon an income approach, that would seem to be consistent with the two Supreme Court cases we've talked about so far, Graham County and TRICO.
But they're not just using they're not using separate cost approaches and market approaches. They're using two approaches, both of which are severely flawed, and then they're assigning arbitrary weights to those to come up with an average between their cost approach and their market approach.
Isn't that what your expert did, except your expert chose also to use the income methodology that's directly disallowed by Graham County?
No, we did not use a weighted approach. We used separate independent approaches. And the approach that we used in the case is a form of an income capitalization approach, but is not a direct capitalization approach, and there's a difference. A direct capitalization approach looks at a single year of income, 1 year, and it's based on actual income. That was what was used in Graham County. What we use is a discounted cash flow analysis. At the time that case was decided, discounted cash flow analysis existed in theory, but not in application. They were not used by appraisers at that time. So we've looked at and used a projected income, not the actual income.
Why would that make any difference under the rationale of Graham County?
Because I think one of the reasons in Graham County that the Supreme Court had a concern was that with using actual income, especially with these properties, the income can vary greatly from year to year. So in 1 year, the income could be very low. You capitalize that income, you get a low value.
Well, I thought Graham County really hinged on the difference between for-profit and non-profit entities.
That was a complaint that the court expressed.
Can't
But-
for-profit entities experience the same fluctuation in income that non-profit entities can?
They certainly can, and if they did, a proper valuation method would not be to use a direct capitalization income approach. It would be use a discounted cash flow approach. The discounted cash flow is used when income is when a property is either unstable, in other words, it doesn't have market vacancy, it's not collecting market rents, the market is in high fluctuation. You would use a discounted cash flow analysis, and that's what we've done here. The other difference is that in Graham County, they only use the actual income. We have not done that here. We have used projected revenues over time.
But isn't Graham county premised on the notion that the company has a disincentive to increase profits?
Well,
Or income that's different than a for-profit?
yes, I think that is something that the court did. That's certainly something that the court said in Graham County. But they also continuously said throughout the case in Graham County that they set their rates with the intention of not making a profit. And in the briefing, I think we've demonstrated that's simply not the case. Sulphur Springs has the 7th highest utility rates in the state. It has higher utility rates than investment owner utilities such as APS or Tucson Electric Power. The top 4 electric rates in the states are all rural electric cooperatives. It's not that they're setting their rates low. It's just that the expenses necessary to operate these types of properties are much higher than a typical investor-owned utility because they cover a much larger geographical
Is the
area.
income approach based on a gross income as opposed to, or does it not factor in expenses?
It does, and these properties have a higher rate of expenses, and that was reflected in our appraisal report.
The department has used this evaluation methodology for a number of years, hasn't it? As it relates to your client?
Mhm.
And if I'm remembering the record correctly, your client has acquiesced in that valuation for a number of years until these protests were filed. Do I have that right?
You're correct, and that's a good question. I think what did occur in this case is that for years, the valuation on this property had been fairly consistent. If you look at the 5 years prior to the year we appealed, the average value was around $100 million. If you look at the 5 years after we've appealed, the average value has been $200 million. Then the year in particular, between the 2009 and then the 2000 year, which is the first year in this appeal, I believe the value jumped 46%. It's those sorts of actions which do catch the attention of taxpayers and therefore finally make them go, wow, we need to do something here. So you're correct. They did acquiesce in this.
Is the taxpayer, like your client, in a position to initiate or to revive the rulemaking process, to propose a different valuation method? They
have. In fact, a new statute was passed in 2013 to address the valuation of these types of properties. As you, from reading the briefing, the methodology now is just standard appraisal method and techniques, the same it would be for an office building or a vacant parcel of land. Now there's actually a statutory formula which is similar to the statutory formula which is used for investor-owned utilities with one exception. There's now a market value factor which accounts for the obsolescence due to the restrictions or the government regulations on these types of properties. And that's the difference between how like an APS is valued and how these types of properties are valued. So yes, they've done that, they've addressed it, and now there's a statutory formula. So this case really doesn't affect anything going forward. It only affects these cases that are already in the pipeline.
Do you contend that the Supreme Court decided Graham County incorrectly?
No, I don't. I think that the valuation methodology that they ruled was not a standard appraisal method technique. The direct capitalization of income, that is correct. That's why we have used the discounted cash flow analysis. It is an income capitalization, that it is, but it has different features than a direct capitalization income. It projects and estimates revenues over time and discounts the cash flows to present value with a reversionary interest calculated to determine a value. And that is different than capitalizing 1 year of income. And we've taken that into account, and I think that's really important when you look at also, if I may, what our appraiser has done, and this is from the record 85, index of record 85. On our valuation report on page 16. This is what he did. The company he works for is Shaw Consultants. So this is quoting from it. Shaw Consultants utilize customer growth, That would not be something used in a direct capitalization. You just look at whatever the income was for the year. So he looked at customer growth, average sales per customer, average rates by customer class, projected revenues, projected expenses, and projected capital expenditures contained in the financial forecast to project future cash flows. And future revenues were increased to reflect the recovery of market interest expense sufficient to maintain what's called a target tier 1.3. The target tier 1.3 is the financial standard that banks and other financial institutions that underwrite these types of things look for to make sure that they're meeting the financial requirements, okay? And if you look at, we mentioned this in our brief, if you look at recreation centers versus Sun City, Supreme Court case, it directly addressed what the legal standard is for valuing properties that are for nonprofit purposes. And it said, standard real estate practice permits the appraisal to value property of nonprofit organizations to determine the appropriate mortgage loans. If the property has enough value to satisfy a lender, despite its owner's nonprofit status, it is probative of its value for tax purposes. Our appraiser did that. He calculated, he not only did all the projection of revenues, but he also did this, and he also looked at it in terms of he increased the revenues to reflect the market interest expense sufficient to satisfy the lending criteria in this case. And they've done that. The appraisal takes that into account, and it satisfies the standard in recreation centers for valuing nonprofit properties. My time is up, but for now, I'll reserve the last 5 minutes. Thank you.
May it please the court, my name is Kenneth Love. I'm an assistant attorney general. I represented the defendants at the matter below. I represent the appellees here today, and with me at council table is my colleague McCain Mahoney. I believe that the court has fully recognized the import of what I call the Graham 2 decision, and I think that we need to address, or at least address this notion that somehow there's a distinction between direct capitalization and discounted cash flow that would have been allowed under the Graham 2 decision. And I think in order to do that, we have to look back at this nice package of cases that has been presented to us, starting with the TX 1 decision. And it's interesting in that case. TX 1 was a case which clearly was set upon by the fact that there had been a direct capitalization of income performed by the appraiser for the taxpayer. And in that case, the tax court, or the court, issued the statement assuming arguendo that there is the ability to do a discounted cash flow valuation. We're not going to do that in this case because we're dealing with direct capitalization. The case went on to note that there are two varieties of state laws that touch upon this issue. There are states which expressly enable the appraiser doing the valuation of a nonprofit entity to use a discounted cash flow, and other states which expressly exclude any utilization of income approaches. The issue could fairly be said to be somewhat up in the air. The subsequent decision in Graham County 1 basically struck the Court of Appeals. This court said, well, no, this is an income valuation that's premised upon actual income as opposed to anything projected or DCF. I think it stands to question why the Supreme Court took review of that decision and basically vacated that decision. And what the Supreme Court did, and what I believe that this court has recognized, is that it said that under no circumstance is income to be used, because income utilization in the valuation of a nonprofit entity, an entity which creates its rates with the direct goal of not creating profit, is fundamentally flawed. And I believe that, in the face of a decision previously that said, well, there are cases that say, clearly we're not going to let direct capitalization stand. There are two types of cases, one that's direct capitalization, one's DCF. We don't know, we're not ruling on that, and suddenly the Supreme Court doesn't suddenly, I'm sure it occurred over a period of time, but over the short period of time, says, wait a second, the Court of Appeals has just ruled DCF, or direct capitalization, is no good in this case. That's only affirming the first TRICO decision. Here we're going to step in, we're going to review, and we're going to say that utilization of income for not-for-profit enterprise is fundamentally flawed.
So counsel suggests that from a historical analysis here that when Graham was decided that this discounted cash flow model was a theoretical model and not one that was had been put into place by the industry, and since as time has passed, it has now become a model that's actually used in the industry to value these nonprofit entities, and therefore it's an appropriate valuation technique to use. What do you say about that?
Well, I don't know that in the industry is an appropriate consideration, and I'm not even sure that the facts support that contention. I think that, as we noted in our brief, discounted cash flow had been a methodology that had been in use since the 1800s in the English coal field. So to suggest that it's a new methodology is somewhat imprecise. But I think that if indeed there are instances in which appraisers have utilized DCF, they probably did it in states that do not have the preclusive effectiveness of the Graham County 2 decision. And very clearly, appraisers are bound to follow the rules of USPAP, which are the appraisal rules. And basically, USPAP says there is a jurisdictional exception to the utilization of various types of approaches. In this case, there's a very clear jurisdictional exception, and that lies in the Graham County 2 decision. I do want to address something that has been raised, and I think that what the appellant has failed to grasp in this instance is that there is a presumption of correctness, and it can only be rebutted by competent evidence. It doesn't say any methodology that you choose to select. They ignore the fact that there's not competent evidence that has been presented because the evidence is rendered incompetent by Graham County. But then they go on to say, well, perhaps you should overlook that shortcoming because our expert, Dr. Heaton, basically has poked some holes in the department's methodology. The methodology that I think that you all have clearly grasped has been utilized for many. Well, I think that there are 9 nonprofit cooperatives in the state, and so this methodology has been used somewhere in the neighborhood of 150 to 180 times.
Sorry to interrupt. Is there anything wrong with Mr. Heaton's analysis outside of Graham County? You say we didn't have Graham County. Do you take issue with his approach?
I didn't really address Mr. Heaton's analysis. I didn't care to rebut it because of this, and I'll read you this statement from Graham County that I think is very important. The taxpayer in this case is to establish that the assessment was excessive, offered evidence directed against the method of valuation used by the department and also evidence of a different full cash value. Here's what the court says. While there may be some question as to the method used by the department to establish the valuation as to whether it actually meets the requirements of the statutes of a standard appraisal method and technique, it is clear that the taxpayer failed to establish by competent evidence a different full cash value. Now, what that is basically saying is unless the taxpayer can meet its prima facie case of the presentation of a valid or competent valuation, it doesn't get to go into the tax court to debate the bona fides of whether or not the department's methodology is correct or not. That's basically Graham County said, look, there's a presumption of correctness. Unless you come to us and unless you present a valuation that is based upon competent technique, we're not going to let you go to phase 2, which is to say, we're not going to let Dr. Heaton testify, as to what he believes is an appropriate methodology or not. And very simply put, we didn't direct those issues, nor did we rebut Dr. Heaton at the trial court level, because we believed that there was no necessity for doing so, simply because this initial hurdle had not been met by the taxpayer.
Is Mr. John correct that the valuation changed from year to year by 46%?
I can't address that, and I'm not sure that the record can address this. One thing I know is that during this period of time, the taxpayer took on extensive capital purchases, which would drive the cost approach higher. In other words, if you're replacing old equipment with new equipment in a cost approach, that's going to raise it up. If you're expanding the area in which you're operating, that will increase your cost approach and thereby increase your valuation. So for us to sit here today without a full record, and it really wasn't established, without a full record that discusses whether or not why these particular valuations increased as they did, I think is inappropriate. But I can only offer, my anecdotal recollection of this, that I believe that there were increases in costs and costs as in capital expenditure that occurred during that period of time. But I don't think the record reflects that, Your Honor. I think that Judge Fink at the trial court level appropriately addressed the issue of the, quote, legality of the valuation methodology. And I think that he stood on, in some part, upon the acknowledgement by the appellants, which they're trying to disavow at this point, that what the department did was standard appraisal methods and techniques. That statement, as you, Judge Winthrop, has noted, was clearly a part of their briefing. The fact of the matter is, as Judge Fink pointed out, there is a requirement that these properties be valued. Hence, this attempt through the APA to vitiate the valuation by claiming that it's not within the rigors of the APA lends itself to a rather absurd result, since the properties must in and of themselves be valued. But if you look behind that a little further, and if you look to what a regulation is, and you counterpoint that against what we have here, I view a regulation as this. A department issues a mandate against perhaps a mine and says, your sulfur oxide emissions cannot exceed a certain amount. Very clearly, that regulates the operation of that business. But what's being done here instead is not the imposition of something upon the business itself. It is a direction, kind of an internal direction, to the department's personnel as to how the department can value what is admittedly a very difficult property to value. You know, that also comes from Graham County. It says utility companies are difficult to value. Nonprofit electric cooperatives are even more difficult to value. So, you know, there has to be some kind of direction. And the suggestion that this is a strictly adhered to policy, well, it may be a methodology that commences, but what the taxpayer fails to consider is the fact that there is a reconciliation process whereby the appraiser does a cost valuation and the appraiser does this sales comparison or market analysis, which is a hybrid, admittedly. It's a unique methodology, but it does attempt to be more or less a stock and debt approach for an entity that doesn't have stock. Irrespective of that, the appraiser has two values. Now, you can call the appraiser's judgment arbitrary in terms of how he or she utilizes those valuations, but this is something that takes it out of, you know, the strict adherence, the strict statement to someone, you shall not have sulfur oxide sulfur oxide stuff coming out of your plant that exceeds a certain percent. There is a appraisal judgment figure that is in there. Well, that's no different, in fact, than anything that appraisal does. Appraisal is not a science. It's important to recognize that, and our courts have recognized that it's not a science. It is an art. It calls for determinations of what values both meet the circumstances of the property that's being valued. And so to suggest that there is such strict adherence to this so-called rule, which is not really a rule, which is nothing but the embodiment of a standard appraisal method and technique, really belies the fact that this is merely appraisal in its perhaps greatest artistry, but one that the taxpayer could find fault with had the taxpayer come to the court with a valid figure and said, no, your $200 million figure is not correct. Here's why. Here's a cost approach. Here's a sales comparison approach if you can find enough property to compare with, but you can't because these things aren't sold. They're not really saleable properties, and the taxpayer hasn't done it, and it hasn't met its prima facie obligation, and accordingly the tax court granted summary judgment in favor of the department.
So just so I understand this, with respect to the department's valuation approach, that the artistry involved in the appraisal, that doesn't translate into the taxpayer being allowed to introduce any element of income into its valuation proposal.
Not to the extent that it doesn't meet Graham County, and I think that these assertions that basically, and I think I know what your thought process is. Well, I don't deign to know what your thought process is, but if you believe, in fact, Dr. Heaton's suggestion that what the department has done in its sales comparison approach is basically some form of income approach, Graham County still doesn't let you get there. It still doesn't let you get there. I mean, you could, at a certain point, if you had come to the court with a valid, competent evidence, make that claim. But failing to make that, failing to provide competent evidence, Graham County precludes you from going that extra mile to basically say, no, you know, this is really an income approach and sales comparison approach clothing, but you don't get there because they haven't met the prima facie case. And failing that, even if there are, and I think that the Graham County case, Graham 2, was very clear. Even if there are infirmities in the department's valuation method, you don't get there where, in fact, the taxpayer's valuation is premised upon something that is fundamentally flawed. And going back to this issue of whether there's appropriate computer technology to enable people to do DCFs, yeah, I think that the computers have been a wonderful aid in valuation of property, but the court in Graham County wasn't concerned with the methodology of how the valuation was performed. It was performed with the inherent unreliability under the circumstances of the utilization of anything related to income, an income approach in valuation that would be used basically by an entity whose intent is not to earn profit. I think that our briefs make it abundantly clear the position that we've taken. I think that they fully support and that the tax court's judgment was correct, both as to the Arizona Administrative Procedures Act and as to Graham County and the application of Graham County to this matter.
Could I ask you about the 2013 legislation? In your view, how does that affect things going forward?
Well, it affects things going forward. It basically enables the department to utilize this formula that's been, the taxpayer to have the benefit of the formula that basically the legislature has enacted. I think that's at 4214159, in case anybody is interested in looking at it. To a certain degree, it takes out any subjectivity, which is generally the process that's involved in the enactment of cost-based statutes, and that's what it is. But it has no bearing on this case as to clarification or any other rules of construction that would have to do with it. And I might add, the department did not oppose the enactment of 4214159. In fact, worked with industry toward its adoption. So it's a moot issue going forward. The only issue that remains on the table are these tax years that are issued in this case. Thank you, Your Honor.
Thank you. Couple of comments. First of all, you mentioned their market approach, which, as we mentioned, they use an income approach within their market approach. With regard to their market approach, this is what Dr. Heaton had to say. It is a method that appears in no finance or appraisal text I have ever seen, and it violates fundamental financial principles. When the person who administers the evaluation of this, Ms. Gwynn, and the testimony is in the record as well, was asked how it all operated. She seemed to have very little idea of how any of this operated at all. It was on like autopilot. They've been valuing these for years and years and years. With regard to the methodology in Graham County and the discounted cash flow, again, in our brief, we cited numerous sources showing that the court never considered. DCF was never on the table at all at that time. So it never ruled on it. And we're not asking you to overrule Graham 2. We're saying that in this circumstance, that the methodology used is distinguishable from the methodology that was used in Graham 2. So again, we're not asking you to overrule it. We're saying it's distinguishable from.
Well, it seems the main way you're distinguishing it, if Graham 2 says we're concerned that nonprofits tend to set their rates using different economic considerations, your rejoinder to that is that our rates are really high.
No, we don't set the rates. The Arizona Corporation Commission sets the rates. We don't. Just like they do for investor-owned utilities, the Arizona Corporation Commission sets the utility rates. We don't.
So then you're contending there's no difference between nonprofit and for-profit.
No, I'm not. I'm just saying that they set the rates.
Okay.
We have higher rates than that. And if you look at the last rate-making case, we requested I believe it was a 10-point $6 million increase in our rates. The Arizona Corporation Commission only gave us 7.4.
Okay, but then how does that relate to the rationale of Graham County?
That's one of the problems with Graham County from our perspective is it continuously repeats this phrase that we are setting our rates with the deliberate intention of not making a profit. But the record is clear. That just factually is not correct.
Okay.
That we don't.
I was under the impression that you had no quarrel with Graham County. Was I wrong?
We have no quarrel with their decision as it pertains to the direct capitalization of income. With respect to the statement that we set our rates with the deliberate intention of making profits, we do have a quarrel with, because it doesn't fit with the record and the evidence of what has happened here and the fact that we do have some of the highest electricity rates. We charge some of the highest in the state. The main reason these properties do not make the same level of profit or rate of return that investor-owned utilities do is because of the cost. That's why investor-owned utilities do not operate in rural counties. And that's why the whole scheme was set up in the 1930s with the Rural Electrification Act. And that's why they're nonprofits. They're nonprofits so they don't have to incur income tax. If they did, nobody would ever build these in these areas. So that's why they're structured as nonprofits to begin with, is to get the tax benefit to induce them to build these either distribution or generation facilities in rural areas and supply electricity to rural areas throughout the state. So, any other questions at this time? Okay. Thank you very much for your time.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. Thank you. We'll take a brief recess.